Good afternoon, everyone. I'm really delighted to be here this afternoon because I probably thought that I was done my speaking roles in this particular event, but I'm delighted to have been asked to welcome all of you to the 2016 Adams Lecture and to say just a couple words about Judge Adams, which I am really honored to do. And Nessa, it's really wonderful to see you here, and I'm really delighted that we can continue this most wonderful series, even now in this bittersweet year without Judge Adams. As many of you know, Judge Adams was an esteemed member of the judiciary. He served for 17 years on the Third Circuit. And he wasn't just any judge of the Third Circuit, he was a most cherished member of the Third Circuit. And as we know, it was publicly documented, he came this close to being nominated to the Supreme Court, not once, not twice, but I think it's on 3 occasions. And that was a real testament to the wisdom that he brought to his role as judge. He was a good man and a smart individual and a just and kind jurist, and a wonderful husband and father, and as I often like to say, a little bit of a flirt. It was always fun to be with him because he had this twinkle in his eye, and he had that remarkable ability to make you feel like you were the only person in the world. He made you feel as if you mattered, and his conversation with you was important to him. And I am delighted that we are continuing this lecture series that Judge and Nessa Adams endowed to talk about the importance of constitutional principles and to remind us about the place of the law in our lives and the importance of diversity of thought. And so it is really my privilege to introduce my successor, Greg Mandel, who is the interim dean of the law school, who is going to be introducing our guest speaker. But thank you very much for the chance to greet you one more time, and I'll look forward to next year when I'll just be a member of the audience. Thanks so much for being here. I forgot to say that I have to be at the Board of Ethics at 1 o'clock, which is the reason that I'll be sneaking out before this lecture is probably over, but thanks.
Thank you. Thank you, Joanne. And I want to add my own gratitude and my condolences to the Adams family for joining us here today and for creating this lecture series. Both the more traditional meaning of family and also his extended clerk family, who a lot of whom have joined us here, and we appreciate seeing you all. Judge Adams was a true friend of Temple Law School, and we are very grateful for your having shared him with us and for the wisdom that he imparted to many of us here. Our speaker today needs no introduction for many in the room. Professor Peter Spiro is the Charles Wiener Professor in International Law here at Temple Law School. He is an expert in international law, in immigration, and in constitutional law. And he is an extremely prolific author. He has written many articles, chapters, essays, both for an academic or scholarly audience as well as for more broader audiences. In particular, he is now the author of 2 books, Beyond Citizenship, American Identity After Globalization, which came out in 2008, and this year, At Home in 2 Countries, The Past and Future of Dual Citizenship. Peter's work is recognized around the world. He has held numerous prestigious fellowships. I will just note one at the European University Institute, at the Council on Foreign Relations, and at the Open Society Institute. His commentary appears regularly in many national and international publications, including the New York Times, the Wall Street Journal, the New Republic, Foreign Affairs, many other publications. And he is routinely ranked among one of the most cited scholars in the field of international law. Peter clerked for Justice David Souter on the U.S. Supreme Court, and he also served as the Director for Democracy on the staff of the National Security Council and as an attorney advisor in the U.S. Department of State's Office of the Legal Advisor prior to entering academia. He holds his bachelor's degree from Harvard and his law degree from the University of Virginia School of Law. To many in this room, Peter is also a fabulous colleague and a very good friend. I mentioned a lot of areas of expertise, but his primary focus is on citizenship. That's the topic of both of his books. That is going to be the topic of his lecture for us today. And he has received wide, high, and well-deserved praise for these works. I am choosing just two quotes from numerous folks who have recommended this work. Gerald L. Newman, who's a distinguished professor at Harvard, praised Peter's work for, quote, humanizing the subject and also conveying eloquently how globalization dilutes older ideals of citizenship. And also Roger Smith, a professor at the University of Pennsylvania, called Peter's work, quote, provocative yet engaging and a major statement that will inform and influence citizenship, scholarship, and political debates for many years to come. So Peter's remarks today are going to tell us about how the Constitution's and the Supreme Court's actions and form have helped facilitate the acceptance or the growing acceptance of dual citizenship recently, last few decades. A status that has gone from something that was once considered an anathema to something that has become very common. Peter is going to speak for a little while, and then we will save some time at the end for questions and answers. So it is my pleasure to introduce Professor Peter Spiro.
I'm a little shorter than Greg, so thanks to Greg for that really gracious introduction, and thanks to all of you for coming today. I'm really honored to be giving a lecture in Judge Adams' name. One thing that I'd highlight in his record is the fact that he was a Republican, and that he was the nomination would have been from the Nixon administration. I think in some ways that's something we should celebrate as a contrast to today, because all the nice adjectives that Joanne was throwing in his direction, all of which were true. I did have the honor to meet him a couple times at the earlier versions of this lecture. Those would be a little unusual today to be thrown in the direction of Republican jurists. And Judge, it sort of should remind us of a time when there was much more civility across the political aisle, and in which there was a sense of mutual respect among between the parties, and unfortunately we don't seem to be at that place today. So I would celebrate that element of Judge Adams' experience and the time in which he served. So what I'd like to talk about today is dual citizenship. And let's see, do I have a clicker hiding here? I guess I can always just. There we go. So, this is my German passport, which I applied for on the basis of nationality that I secured in 2012 on the basis of being the son of a German Jewish refugee who was denationalized by the Nazi regime in 1941. And so the question I'd start with is, why did I bother to get German citizenship, other than maybe to prove that bad passport photos exist in any language? And so the answer is partly of academic interest. So this is a subject that I've been studying for 20 years. And so when I learned that I was eligible to become a German citizen and to have dual citizenship, it was something I thought I should basically undertake by way of enacting my scholarly work. But it also does come with some benefits. The ability to live and work in the EU pretty much without restriction, which is not something that I'm likely to avail myself to, but my children might. So I also got German citizenship for my son and daughter, and then it's a case of you never know if they want to do graduate work or work in the EU, so that actually could be a potentially significant benefit. And if nothing else, it means that I can go through the shorter line when I'm flying into the European Union state, which just last week I had meetings in the UK and Italy, and in fact, there was a very long line for the other passports or all passports line relative to the European Union passport line. So given that the citizenship comes at no cost, there's no obligation that's associated with it, even this fairly trivial benefit that comes with the status makes it seem worth doing, and didn't take too much work. It was a question of assembling some birth certificates and passports of my ancestors, so it wasn't difficult. And I'm not alone in doing this. So among native-born Americans, there are now many who are, for instance, getting Italian citizenship, and there actually are boutique tourist agencies now that will arrange a nice trip to Italy. And the sort of the incidental benefit of which is you come home with an Italian passport. And they charge, it's a little more expensive, I think, than just the accommodations because there is some legal work involved. But a lot of Italian Americans are doing this on the basis of a single grandparent who's born in Italy, and also many Irish Americans. That Irish American, and I see at least one person in this audience who has Irish citizenship also. It's almost a matter of just going to the consulate in New York and signing up. I mean, it's quite an easy process now. So there are a lot of Americans doing this, and there may be a lot more as of this week. There may be now some who feel that for political reasons it's good to have the extra passport. And the question is sort of how did we get to a point where this is now pretty commonplace? So when I teach immigration law, I always at the beginning of the year ask students for their immigration histories, and I also ask if any of them are dual citizens. And now there's always someone, and usually several students in the class who have more than one citizenship. And yet we have statements like this from the mid-19th century. I mean, this used to be considered dual citizenship, dual nationality, and more appropriate label in the historical context, really used to be considered an abomination, a moral abomination. And the standard comparison, as in this quotation from George Bancroft, who was a prominent diplomat in the mid-19th century, was to polygamy. That you could as soon have tolerate a man with two wives as a man with two countries. And that was a pretty standard framing of dual citizenship in the distant past, and then even the not so distant past. There's still some who frame dual citizenship and with the marriage analogy. But in the 19th century, it was universally considered an abomination, and so the way it was that states attempted to police against it, in the United States in particular, against those who were born with U.S. citizenship, but then sought to secure another citizenship, was through the mechanism of expatriation. So I should have said that I would never have gotten German citizenship if it put my U.S. citizenship at risk in any way, right? I'm American. That's where my social membership is. That's my identity. That's where I live. So I wouldn't have acquired German citizenship and the relatively trivial benefits that it poses for me if there were any risk in forfeiting my American citizenship in the way that used to be the case. So it was once the case that through the mechanism of expatriation, first through administrative practice of the Department of State, then through legislation. The first Expatriation Act was enacted by Congress in 1907. If a native-born American naturalized before a foreign state, then you would lose your U.S. citizenship. And that practice and legislation was upheld by the Supreme Court. So a series of cases through the middle of the 20th century, the court upheld involuntary expatriation, that is, where individuals did not wish to lose their citizenship, and challenged it in the Mackenzie case under the 1907 Act, where, quite an interesting case in terms of its factual background, a suffragette, Ethel Mackenzie, shows up at the voter registration office in San Francisco, and not only to vote for the first time, and not only is she told that she can't vote, she's told she's not a citizen anymore because she had married actually quite a prominent Scottish tenor opera singer named Gordon Mackenzie, a citizen of the United Kingdom. And under the 1907 Act, women automatically lost their citizenship by virtue of marriage to a non-citizen man. A legislative mechanism which was in place until 1932, from 1907 to 1932, and she challenges her expatriation here. And the court upholds it because the underlying condition triggering expatriation was voluntarily entered into. So she challenged the expatriation as unconstitutional. The court upholds it on the basis that the condition of marriage was voluntarily entered into with notice of consequences. That expatriation was later upheld in Savignon versus United States, which involved, by this time, the marriage basis for expatriation had been eliminated, but it was still the case that foreign naturalization would result in automatic expatriation. And in this case, a St. Louis woman married an Italian diplomat, and unbeknownst to her, she signed a bunch of documents in Italian which naturalized her as an Italian. And so she didn't really have any idea what was going on. This was a condition to her marriage to the Italian diplomat that she acquire Italian citizenship. And in that case, even though on a sort of ignorance of the law is no excuse basis, her expatriation was also upheld. So we have the court upholding this regime, which is suppressive of dual citizenship. So very low tolerance for the status. And then in the zenith of this, what I call hair trigger regime for expatriation, the Perez versus Brownell decision, in which an individual was expatriated, lost his U.S. citizenship for the mere act of voting in a foreign political election. So that was one of the grounds for expatriation. There was a case involving a woman who voted in a municipal referendum in Canada on a question relating to whether beer and wine sales should be legalized. That counted as a foreign political election, resulting in termination of citizenship. So it didn't take much. It was never the case that dual citizenship was illegal under U.S. law, but basically any form of active dual citizenship, including as minor an action as voting in a foreign political election, would result in automatic loss of citizenship, and under a regime that was sustained by the Supreme Court. So you couldn't really be openly an open dual citizen, an active dual citizen. And there were lots of social norms which backed up the status. So this was the social norm of, it's like bigamy. So it was not a status that one advertised. So that changes though with, well, we get a pointer towards change in Chief Justice Warren's dissent and the Perez case, which is probably the most, one of the strongest statements of what I call citizenship triumphalism, that one finds in the U.S. reports of citizenship being man's basic right, because it's nothing less than the right to have rights. So, and the idea that the government could take away the foundation for all other rights to Justice Warren was an anathema, and then to Justice Black as well. So Afrim is this inflection point in terms of the jurisprudence relating to expatriation with its heavy implications for dual citizenship. Afrim, like Perez, involved a case of foreign political voting. Afrim was an American citizen who moved to Israel before its independence and voted in the first election in Israel, actually before the Israeli state even existed. So he wasn't a dual citizen, but the State Department sought his expatriation, sought to terminate his citizenship on the basis of his voting in Israel. And the Supreme Court here strikes down the expatriation ground those of you that work with mid-century Supreme Court opinions in very Justice Black, sort of true to Justice Black, very absolutist terms. Textualist, there's nothing in the Constitution that says you can take citizenship away. You've got the 14th Amendment, which gives everybody born in the United States citizenship, and so he rejected that there was any power to take the citizenship away. And this is really the turning point in terms of setting the groundwork for a toleration of dual citizenship at the same time that it took. And in the book, I tell this story. It was not an immediate consequence of Afrim that dual citizenship was accepted, but through changes in State Department policy and follow-on opinions by the Supreme Court, one in particular, the Vance versus Terrazas decision in 1978, which came to a point where, even though it remains on the books to these days that naturalization in a foreign state will result in loss of U.S. citizenship where there is intent to relinquish U.S. citizenship, now, as set forth in this Department of State policy statement, it is always assumed that an American acquiring another citizenship, a native-born American acquiring another citizenship, intends to retain U.S. citizenship. The only context in which it even raises eyebrows in the State Department is if an American citizen is about to become the head of state of another country. That's when you can expect a phone call from the State Department it's such a good idea that you keep your U.S. passport. There have been cases, especially in Eastern Europe, where you had many exiles from Soviet occupation of individuals running for and serving in actually high policy-making positions who did not give up their U.S. citizenship. There was one, Vladimir Adamkus, who ran for president of Lithuania in the 1990s, who did, and this is often also, of course, required by your local constituencies that you not have this alternative affiliation. So it's now the case that it's absolutely tolerated. So for a native-born citizen to acquire another citizenship, it's just no problem. No risk of losing your U.S. citizenship. So that's from the perspective, and so the Supreme Court played this important part in paving the way for changed administrative practice towards complete acceptance of the status. It's also working in the other direction. So immigrants to the United States who are naturalizing as Americans now in almost all cases are retaining their citizenship of origin. So almost all naturalizing Americans are American citizens and dual citizens at the time that they acquire U.S. citizenship. There are no statistics kept on the phenomenon, but one can sort of put together some estimates based on the default position now of other states. So at the same time that the United States has grown to completely accept dual citizenship, other states have as well, and some states actually have moved to encourage it. So-called sending states who want to empower their immigrant populations in the United States and elsewhere, and also with whom the sending states want to cement ties because immigrant populations are now considered to be an economic resource. So 9% of all Mexicans live in the United States, and they send a lot of money home. And so it's at one point until the late 1990s, immigrants from, and especially those who naturalized in other countries from the so-called global South, were considered to be traitors. There was a quite widespread urban legend among Mexicans that as part of the U.S. naturalization ceremony, you had to spit and stomp on a Mexican flag. So that didn't look very appealing. Certainly not from the homeland perspective, that these people who acquired U.S. citizenship had disrespected the homeland in this way. But that's now a thing of the past, as Mexico under this and other sending states have come to understand the importance of their external populations. And so they now not only tolerate the status but encourage it. And so since Mexico changed its law in 1998 to make it the default position, retention of citizenship, the default position, there are about 1 million Mexican nationals who have naturalized in the United States. And I'd say basically all of them are dual U.S. Mexican citizens. Interesting, I want to leave some time for Q&A because this subject has the virtue, I think, of being an accessible one, and so I always like to take the discussion wherever the audience wants to take it. But a question here is why dual citizenship has never really been on the political, has never really been politically contested in the U.S. And if it was ever going to be contested and made into an issue coupled with immigration, it was when Mexico changed its law. And I was at a conference down at Duke in 1998, just as Mexico was changing its law, and I was at a dinner, and I sat next to the chief counsel for a very restrictionist Republican congressman, Lamar Smith, who's from Texas, who is very anti-immigration. And so I was chatting this guy up and sort of saying, so what do you guys have any plans to start policing the status now that Mexico is, the change in Mexican law is going to result in a large number of Mexican and American dual citizens? And his response was, I've got some nieces and nephews, and they've got Irish and American citizenship, and they're good kids. That was it. That was it. So it explains how citizenship has been citizenship policy, including dual citizenship policy, has been decoupled from immigration politics, the pathologies of immigration politics, to the extent that it implicates very powerful constituencies. It doesn't map onto immigration politics in the same way, to the extent that you have powerful constituencies, including Irish Americans, Italian Americans, Jewish Americans, that all have now a vested interest in this status as a matter of formalizing very strongly held identities. So the trend is unidirectional, and this is true both among sending states of the South and receiving immigrant states of the North, all of which are now sending states in some way. So you'll get native-born Germans and native-born Dutch who are, for work reasons or other reasons, moving outside of their country, and they want to keep their citizenship, even as they secure citizenship in their new country of settlement, and that creates pressures on home governments to accept the status, and there's been quite a dramatic shift from almost no acceptance to something that's starting to approach universal acceptance. There are holdout states that I call. Japan is probably the most notable one that actively polices against the status. There are others that, for contingent reasons, like India has a constitutional ban against the status. In China, it's formally illegal but very erratically policed. So most countries now, a majority of countries that formally accept it, and then even among those that don't, it's tolerated. It's tolerated to the extent that it's not policed. So this has now become really a commonplace of globalization, not just in the U.S. but in other states. And this is it's gone from being a moral abomination to, last year I had 2 events where I was speaking to college freshmen, one at Princeton and one in the UK, and I just asked them, because I've now lost touch with that generation, I just asked them what they thought of dual citizenship as a status, and one answer I got was cool, and in the other audience it was hip, and this was without prompting the second audience. So I think 2, Dave, that's a good enough data set, isn't it, right? In terms of, it's clear that the social norms that were once attached, social norms of disfavor that were once attached to the status have now largely dissipated. And it's been interesting working on this subject during 20 years, how even during those 20 years, it's the attitudes towards dual citizenship have shifted from something that, when I first started in the mid-90s to look at this, was still considered anomalous, sort of an oddity. People would ask whether it was illegal, to something now that there's a generational split on this. So there's still some in more senior generations where this seems that there's something odd or even wrong about it. But I think that's something that in the younger cohort is now pretty much dissipated. I'll just finish with 2 more slides. It does enable the instrumentalization of citizenship, right? So gaming dual citizenship, there are 2 contexts that I addressed in the book, that one of which is gaming the status, which we see in the context of the Olympics every 2 years. So individuals discover that they have a grandparent from a country in which they're competitive, right? So somebody who doesn't make the U.S. swimming team has a grandparent from the Marshall Islands. And even though the person has never visited the Marshall Islands, she's eligible for nationality in the Marshall Islands, and the Marshall Islands is glad to have her on their team. Sometimes they're glad only if the competitor pays his or her own way, but they're glad to have them march represent the country, and that's a context in which it's gamed. The other context in which it's not so much gamed as commodified is the increasingly common context of citizenship by investment. And again, with the Olympics context, that person is never going to give up U.S. citizenship just so they can compete, through the semifinals or until the semifinals in swimming. They're never going to take on Marshall Islands citizenship if it means giving up their U.S. citizenship. So dual citizenship is a necessary part of the picture to enable that kind of strategic use of citizenship. And the same thing with investor citizenship, which is now turned into a real industry. I mean, there is a sector that has emerged under the label citizenship planning. So, and you can, for 1 million euros, get citizenship in Malta, which, guess what? Not many of these people want to live in Valletta. But when you get citizenship in Malta, you have Schengen zone rights for all the rest of Europe. So you get your Maltese passport, and then you go live in Berlin or Paris, or at least for now, London. So that, again, enabled by dual citizenship. And there's quite a market for this. This is a big area. I went to a conference last year, basically of the industry. There's now a nonprofit industry association that includes lawyers and accountants and wealth advisors, all of whom are looking for ultra high net worth individuals. That's an acronym that I had to look up. Whatever the acronym is, it's a consumer. It's basically a consumer base for these new citizenship by investment programs, which there are now a number of states that offer, at different price points that offer this possibility. And here I'll end. I mean, the dual citizenship does fit in, I think, into a declinist narrative of the meaning of citizenship generally. So it just starts to look like a matter of arbitrary privilege. Why is it that just by accident of birth and the fact that I don't really have any kind of organic connection to Germany, I certainly don't identify as a German. I speak maybe 50 or 100 words of German. The first couple of times I used it going into Germany, I was really sort of embarrassed when the immigration inspector starts speaking to me in German. I'm like, and I'm sure, I bet it wasn't the first time that's happened, because it's now actually quite common among descendants of German Jews to secure German citizenship. Many in Israel, and there's just there've been a couple articles in The Guardian recently of UK citizens who are looking to secure EU citizenship in the face of Brexit. But it's like, why should I get to go through the shorter line, or why should my kids get to live and work in the EU, where those of you who are mono citizens, your kids won't have the same advantage? And where citizenship used to be sort of a badge of equality, in this context, it's starting to look more problematic. And that's sort of where I end the book, and where I'm looking to aim my work now is how to unpack dual citizenship as a marker of inequality. I'm not sure there's anything that can be done about it. I think it may just point to the further degrading of the status. But in any case, I'll end there, and I'll look forward to questions that you may have. Thanks. In the back.
Could you say a word about the related subject of serving in a foreign army?
Right. So that was also the question of serving in a foreign army. That was also a traditional ground for expatriation, but only as accompanied by nationality in the country whose armed forces you were enlisted in. And this is sort of the French Foreign Legion example, where you can serve in the French Foreign Legion, and actually you can't be a citizen of France to serve in the French Foreign Legion, and that would not result in expatriation. The context in which this has come up, the sort of related context, is with respect to terrorists. And there have been measures introduced which would expatriate those who are complicit in terrorist organizations hostile to the United States. And interestingly, those bills have gone nowhere. So Joe Lieberman introduced one in 2010. Ted Cruz introduced one in this session of Congress, and they didn't even get hearings for them. And again, I think there's something about citizenship that just doesn't get, it doesn't seem to have legs, even in a context where you'd think this would be a no-brainer for Congress and those who are looking for really counter-terror theater, and yet they went nowhere. Yep.
One of the themes that transcends everything is loyalty. And nowhere in your remarks am I aware of your fostering loyalty. I mean, that was always so basic to citizenship. I think that has to be addressed here, and it's sort of this very cavalier attitude that, well, you're going to have dual citizenship so my kids can go study in Germany. But there is an element of loyalty that was always present, and I'd like to hear your thoughts.
Yeah, so I'm really glad you asked that question. That was sort of absolutely a key part of citizenship norms, and a key part of the discourse which found dual citizenship so distasteful. And so, but I think it's important to look at that loyalty discourse critically. So I'm not sure that there's a story that I tell in the book, which is this. It's a story that's really for more it's for a historian's audience, about the real problem with dual citizenship, which was not actually about loyalty, it was about turf battles between states and instability resulting from those turf battles. And I look at the loyalty discourse as sort of a superstructure that was secondary to these more material reasons for disfavor on the ground. But the way to address it today is, how is it disloyal for my kids to go to school not in Germany probably, but in the Netherlands, say, and get EU tuition rates? That doesn't seem, it's the world in which dual nationality was disfavored was much more a zero-sum world as among states. And now, there are actually not that many contexts in which a real conflict of loyalty would arise by having dual citizenship. I mean, really the only one is senior government officials. And that's one in which you could just handle in the same way that you handle conflict of interests among people who own shares of stock in a corporation. Okay, if you're Irish and American, you probably shouldn't be negotiating treaties between the United States and Ireland. But you can do other things. So that doesn't mean you can't have the status, or have the status in a high government position where you're unlikely to have those direct conflicts. So I think the loyalty discourse is sort of a legacy of another era in which states related to each other, and membership in states had a different significance than it does today. Yep.
I recall, and I just checked, the Naturalization Oath reads, the Naturalization Oath reads, I hereby declare on oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty, of whom or which I have heretofore been a subject or citizen. How can, you described how many Mexicans come naturalized, they can't take that. How do you keep a Mexican citizen and swear that oath?
So really good question, and isn't that sort of beautifully archaic language? I mean, it's almost sort of poetic. And the fact is that that has never been enforced. It used to not matter because it was the laws of other countries that policed against dual citizenship. So under Mexican law before 1998, you automatically lost your Mexican citizenship when you naturalized as an American. So that it wasn't necessary to police against it when other states, sending states especially, didn't tolerate the status. But today, it's unfortunate that naturalizing citizens in their first act, in the act of becoming citizens, are basically having to, at some level, perjure themselves, because they, as I said, almost all of them are keeping their citizenship of origin. And I occasionally get calls from, it tends to be people from British Commonwealth states who say, well, I can't do this, I can't. So it also points to the changed nature of oaths. And the Brits still seem to take oaths seriously, whereas the rest of the world seems to have gotten beyond that. But it's a very good question. It should be changed. Well, the reason we can't change it is because it's sort of opening up a political Pandora's box of, once you try to revisit these sort of long-standing, there's sort of tropes that just everybody, it's just better left alone, unenforced. It's unfortunate that the bottom line is that a lot of people end up having to say something that they don't really mean, but it would be difficult to reach political consensus on changing it. Yep, Lou?
I was wondering why you didn't talk about Trott versus Dulles in your remarks. And as I remember the facts, he deserted,
Right.
And he lost his citizenship, and the court held it to be an Eighth Amendment violation.
Right, so that case was decided the same day as Perez versus Brownell. But the reason I didn't talk about it is because it didn't involve dual citizenship. So it used to be that one could lose U.S. citizenship for the act of military desertion, and that was struck down the same day that Perez upheld the foreign voting ground for expatriation as cruel and unusual punishment, which was also, and I think Warren wrote the majority opinion in Trope, And that was also very much a sort of citizenship as a basic right. But there you had the added element of statelessness, that the individual would end up.
And that was cruel and unusual.
When that counted as cruel and unusual, even at the same time that, of course, the death penalty.
Right.
So that's really putting
It's a key case.
citizenship up on a pedestal that it's more important than life.
Yeah.
Yeah.
It's a key case in
Yeah.
death penalty analysis.
Yeah, interesting. Yep. Scott?
Well, I was just going to follow up on that too, because he used, the word uses the right to have right to life. They didn't have word processors in those days, so I guess he had to type it twice.
Right.
It was pretty much the same phrase.
Yeah.
And I wanted to follow up on this idea of what the content of citizenship is going to be. So, I think the conservative moral response might be to say, well, it's about loyalty. I don't think that's gone. I have a feeling that's going to be back. But, maybe the liberal response is, well, geez, if you need citizenship to get certain advantages, everybody should have a chance to get at those advantages. It shouldn't be, if we're going to have a globalized world, that some people by accident of birth can get cheap tuition in Germany and other people can't. Do you see any kind of doctrine or status notion working itself out that somehow starts to think of citizenship as a kind of right that should be available to people regardless of the accident of birth? Or, congregating?
Right. So yeah, absolutely. No, I think we're starting to see this, and then sort of the leading edges among academics, not surprisingly, because it's not politically very plausible to start. You start getting into a little bit of open borders stuff when you start challenging the rights, the privileges that come with citizenship. But Ayala Chakar, who's a political theorist at the University of Toronto, has an important book out called The Birthright Lottery, where she points out, really, it's a lot of one's life success is just the accident of birth in a particular country where you get privileged citizenship status. Now, she doesn't argue that the policy upshot of that should be that everybody should be able to get U.S. or Canadian or some other premium form of citizenship. What she argues is that calls for redistribution among states so as to basically tax birthright citizenship. But I think citizenship as a form of privilege is now being, I think, rightly interrogated, especially to the extent that it's detached from actual community. So if under what's sort of known as a liberal nationalist perspective on citizenship is, look, this is why we can undertake forms of redistribution is within the realm of citizenship, because individuals share particular solidarities in a way that make them willing to share in ways different than they're willing to share with the rest of the world. And that has been true, but globalization is starting to break that down to the extent that having the passport no longer necessarily reflects an actual solidarity. And my case being a good example where I don't really feel. I was at a meeting, one of these meetings in Europe, and there was a German at the table. I was like, should I even mention that I'm German? No, because it's not. It's because it's yeah. So anyway, I agree. Yep.
You focused on the privileges and rights of citizenship, but what about the obligations? So with respect to the military service, you only mentioned that in terms of a reason for expatriation. But are there no countries which would require a dual citizen to also serve in the military, to pay taxes, to exercise other obligations?
So that's also a really good question, and that points to the fact that dual citizenship was disfavored from the state's perspective for the better part of 150 years. It was also disfavored from the individual's perspective to the extent that it gave rise to duplicative obligations, especially military service. So you didn't want to be, and there were lots of stories, major sort of diplomatic dust-ups between the U.S. and European sovereigns. You'd have Europeans immigrating to the U.S., naturalizing as Americans, and then they went back home to visit their grandparents or cousins or whatever, and the Prince of Bavaria would say, "Hey, where have you been? You're in the army now." So that was a real problem. It was dealt with in the mid-20th century through bilateral treaties under which military service obligations could be undertaken in country of habitual residency. So it was managed in that way. And now, of course, it's very few countries that require military service. And when you look at the obligations of citizenship in the U.S., One, jury duty is the only obligation that's distinctive to citizenship. Taxes are on the basis of residency. Military service, well, you still have, as a male at age 18, you still have to register with the Selective Service, but that's a requirement that's also imposed on permanent resident aliens, and in theory on undocumented aliens as well. And taxes, doesn't matter what your immigration or citizenship status is. So the obligations of citizenship have really diminished significantly. At the same time, the distinctive rights of citizenship have also diminished. So this notion of citizenship as being the right to have rights, well, that's really been overtaken, not completely, but certainly to some extent by human rights. You know, it was a perilous world in the mid-20th century, as World War II demonstrated, not to have citizenship in any state. Statelessness is a perilous condition. Now it's still a disfavored condition, but it's not like it used to be. I mean, it used to be if you didn't have a sovereign to protect you, states could pretty much, you were open season, they could do whatever they wanted to you. And so that citizenship triumphalism, I think, doesn't map out in the same way today as it once did. Yep.
I had a practical question for you.
Mhm.
So I'm an immigration law practitioner myself, and dual nationality most often comes up in the context of maybe a spouse or a child of one of my clients who has dual citizenship. And in those circumstances, I advise that they enter the U.S. using the U.S. passport and enter their other country, the European, for example, using the other passport. I was curious, are you aware, does Department of State explicitly address, maybe in the Foreign Affairs Manual or something, the situation, what if a dual national arrives to the United States and presents their other passport to the CBP agent? Does that information flag in the system that they're also a United States citizen, and is there a particular policy that action they're supposed to take?
So I think the answer to that in terms of the database is no. There's no sort of master role of U.S. citizens. There is, by regulation, it is required that U.S. citizens use their U.S. passports when they seek admission to the United States. So that I don't know if there are any penalties attached to non-compliance with that requirement, and it also makes, I mean, I was thinking of this the other day when I was coming back in the States. Well, what if I lost my U.S. passport? Could I come in on my German one? It would be tricky, I think, and there's an incentive to use your U.S. passport because you don't have to do anything to get in. Even if you're from a visa waiver country, a non-U.S. visa waiver country, you still have to undertake something. You have to basically give a heads up that you're coming to the States beforehand. And so I think that's the basic answer, is that you've got to use your U.S. passport coming in. Yep.
I would think trying to prove your country of original origin 4 generations back might be very tenuous. I mean, how do you do that? It's always been family repetition. Oh, we came from Germany, okay? But what do you have to find? There may or may not, probably is no passport, but do you find it on the log in Ellis Island somewhere? Or how do you do it?
So the Germans are very good record keepers. So even though I had a little trouble piecing together some of the lineage, but I was confident that they would be able to backstop any gaps in my application. For other countries, that's exactly what these boutique travel agents and lawyers are offering, is that they will go back to the village registry and figure out, get the proof that your grandparent was born in a particular country. So it can be tricky, and there's a lot of variation country to country in what's required by way of documentary evidence. But it's a question of it more or less expensive, basically, at this point, that in most cases you should be able, through birth records and others, you should be able to establish, if you've got it, you should be able to establish the descent that gives rise to eligibility for the other citizenship.
Just out of curiosity, given Germany as one example, what, other than being able to whiz through with your German passport, or maybe get some benefits of a scholastic award of some sort, is there any real benefit?
Well, that maybe not for me, but if you want school education in the EU, and it's not just Germany. I mean, when I first did this, my wife was very opposed because she thought it meant that I wanted us to move to Germany. But it's basically EU-wide. And so there, again, for my kids, who knows? I mean, I've got a nephew who's studying in Italy this spring as part of a junior abroad. And he's like, well, maybe I'll just stick around during the summer and get a job. And he can do that because he's got German citizenship. So there are still some benefits. I mean, that's really, in terms of citizenship rights, that's the most important one, is locational security and the absolute right to enter and remain in your country of nationality.
So thank you. I think we should wrap up there. Thank you to the advocates.
Thanks, everyone.